the intention of this terror on our legal team is to make it impossible for us to have lawyers of our choice, so that then the state can be our lawyers, give us lawyers. As I pointed out at our last sitting, I wrote and finished. It's not possible to defend yourself when your hands and feet are tied, your eyes are covered, and your lips are sealed. As is happening in our situation. So my Lord, and we are very anxious to get bail, afraid to say that in the prevailing circumstances, we have indeed sympathized with our counsel and let them off. We are extremely determined to insist on our right for representation by lawyers of our choice. Until that is possible, or until court directs otherwise, I think it's only prudent for us to remain in our prison until further notice.
May it please this honorable court, Thomas Jatiko, Assistant Director of Public Prosecutions. This afternoon, I'm appearing together with my colleague, Richard Biribumbuka, Chief State Attorney, and George Bigira, Senior State Attorney. The three accused persons are present in court. My Lord Counsel, the accused persons are not present in court. My Lord, the last time this matter was before this honorable court, it was fixed for 2 p.m. this afternoon for purposes of hearing of the bail application. We are ready to proceed. Yes.
Thank you very much, my lord. A very good afternoon, my lord. Kizza Besigye is my name. I'm the accused one. And before I address you on the situation of our representation, you not allow me to first register a concern that the last sitting gave me audience, and while I was still addressing you, stood up and left. This was the second time it is happening. It concerns me because we come to court to voice some of our concerns, and we expect that our concerns will be listened to, whether they are agreed to or not, whether they are not relevant, but we expect to be listened to and replied to. My lord, the absence of our lawyers is a matter that we also touched on at our last sitting, where we raised the issue of the situation surrounding our representation, our legal representation. And Mr. Judge, to put the situation we are at today in context, allow me to address you on where it has come from. I guess it is knowledge of the public that we were kidnapped from Kenya, from Nairobi, Kenya, the day we arrived there for a visit, and illegally renditioned back to Uganda, detained at Maki Indian military barracks. Incommunicado, we didn't have, sorry. Yeah, we were detained at Maki Indian military barracks. Incommunicado. We didn't have any access to lawyers, to family, or medical care. And one afternoon, we were told we are being taken to court. So we have actually arrived at court without any form of representation. We were pleasantly surprised to find the then Lord Mayor Erias present at the court, together with a number of lawyers, most of whom we actually didn't know. So we were arraigned before the General Court Martial at Makindye, a court that had long been declared unconstitutional by the Constitutional Court. I'm sure everybody knows that a ruling of the court can only be changed by the higher court. No higher court had changed that ruling, that court was unconstitutional. Our lawyers protested then, those who came with, the Lord Mayor Lukwago then and the team he came with, we protested our being presented to that court. What I recall, the legal man of the court explaining that if you are found with materials which are ordinarily the preserve of the UPDF, you are subject to that court. And they said we had been found carrying guns. That's why we are in the court martial. And I recollect vividly Counsel Lukwago asking the legal man of the court. He had a very, glamorous name. I don't know his what. Name they give the legal person of that court. And he asked him how, if we were arrested from Kenya, the guns found in Kenya could be ordinarily the property of UPDF. And that seemed to create some confusion. And at our next appearance in that court, this man became attached to us, Captain Danish Oya Ora, as we know him now, who had been arrested and detained in Makindye more than a year before our detention. tried in the court martial. Again, because if you are found with a soldier, then you are triable in the court martial. So he became the new reason where being tried in the court martial. In the challenge with our lawyers, one of our lawyers was brutally arrested in the court. His counsel, Kizza. And so one of our lawyers found himself in the dock with us, with his shirt torn and some bruises. Was summarily sentenced to 8 months in prison, 9 months in prison and sent to Italy. Because of the complicated and serious nature of the offenses we were charging. Because these offenses were supposed to have been committed in 4 countries. Switzerland, Greece, Kenya, and Uganda. We asked Senior Counsel Karua to come and help us in our defense. And to lead our team. After Karua applied for a temporary license to practice in our courts and was denied. Took another tug of war and another reapplication, and our insistence that we were entitled to a legal representation of our choice. Eventually, just Senior Counsel Karua was licensed to practice, and she took over the leadership of our defense. Fortunately, on on the 31st of January 2025, the Supreme Court conclusively dismissed the General Court Martial as a court of law to try civilians. We stayed in abeyance without any without representation. Around that time, we had applied for mandatory bail because it was already past the period when mandatory bail had to be granted. And then, of course, what transpired with the mandatory bail is well known to the court. We were denied by yourself, judge, saying that show that we had spent more than 180 days, which of course wasn't the case. And this is what triggered our complaint to the Judicial Service Commission. And wrote an application to you, my Lord, for recusal. That was followed by applications, referral to the Constitutional Court, which were declined. Though we filed then a constitutional petition that has not been heard up to today. From December last year, it was ordered that prosecution discloses their evidence to us. Prepare for trial. And from December, the disclosure only got concluded on the 1st of June. Since the 1st of June, and even before, have been pleading to be given time and facilities prepare our defense. On the first, when the disclosures were complete, before we had had an opportunity to view and hear what was in them, the date of 8th June was set preliminary hearing, and 11th for trial to begin with the witness. Again, our protestations that we could not to go to preliminary hearing before we get to understand what is facing us and prepare out of it how to manage the preliminary hearing or protests went unattended. So we were here on the 8th of June. Before we had the chance to receive the disclosures and discuss them with our lawyers. And the Lord, the former Lord Mayor, now Council Erias Lukwago, presented 7 issues that we believed were critical to be disposed of during the preliminary hearing. And one of those issues was indeed the application for human rights enforcement. Application number 227. There was still the issue of our having not yet received the disclosures in Rosita, discussed them with our lawyers. And in spite of this, my Lord, you directed that preliminary hearing was over. You appointed assessors and asked the prosecution to produce a witness on the 11th. Between the 8th and the 11th, our lawyers again tried to come to Rosita with the facilities they needed. And they were denied. And it was the first time that we learned from the OC Rosita prison, Mr. Mbazira, SSP, court had never communicated to them regarding their allowing facilities that were needed there. And he actually showed us the letter he got from court. The letter written by court the registrar of the High Court simply asked the prison to allow our lawyers to access us on a non-working days. Nothing about facilities. Up to today. To us, my Lord, on the basis of that frustration, that we didn't see what we would come to do on the 11th, when trial was scheduled. Before we accessed what was in the evidence that we are going to be confronted with. And I wrote on behalf of my colleague and myself to explain that the prison authorities and we hoped that our lawyers would convince court that there were still some important preliminary matters to be dealt with. Fortunately, my Lord, the 11th of June, the court decided to hear our application 227 to the Human Rights Enforcement. And gave directives on how it would be managed, the service, response, rejoinder, and fixed the date of 30th of June to hear that matter. As was explained at our last appearance here on the 30th, Council Lukwago was preparing to go and serve respondents General Muhoozi Kainerugaba, respondent Colonel Besigye, and Lieutenant Colonel Erias. His home was invaded. He was grabbed. And detained by the very respondent that he was supposed to serve, General Muhoozi Kainerugaba. During which detention he was tortured. Pictures of him under that torture published by the respondent, General Muhoozi Kainerugaba. He was later dumped at a police station and that afternoon charged in Buckingham Court within his prison of the very prison charges he has been representing us. Since we first appeared in Makindye General Court Martial, up to the time of his detention was about 18 months while he was representing us of the tribe. 19 months, sorry. 19 months. And during all these months, up to the time all the disclosures in the case had been tabled, had never been known that we had something to do with the prison he was defending us for. My Lord, more importantly, the reason his pictures under torture are published is not just meant to injure him, but to terrorize all those who may be associated with our case. As I have pointed out, he was now becoming the third victim. On the 21st of June, Council Martha Karua was coming into Kampala to, among other things, indeed, engage with what was happening to her lawyer, colleague, in this matter. She was detained at the airport. For several hours and later deported and declared the persona non grata. My Lord, other members of our team similarly reported threats to them of different nations. So at this stage, my Lord, it was clear that our legal representation was in crisis. Was untenable. And with some of the remnants of our lawyers, in desperation, we asked them to file an application for further human rights enforcement to raise the question of what was happening to our lawyers, the legal representation. Lord, that was how we came here under those circumstances on the 30th. And as our lawyers explained, we came here with full knowledge that 3 of the respondents hadn't been served with the application. Certainly, our lawyers hadn't served them. And that they hadn't responded. Indeed, they haven't. So, my Lord, we hoped that court would listen to our crisis. And though, my Lord, you mentioned that what had been filed as an application 248 hadn't been yet drawn to the knowledge of the court. But information was passed on in this court about its presence and its purpose. On that day, my Lord, you chose to start with our bail applications, which are the reason we are here today. Application was filed on the 20th of May and assigned to this court on the 21st of May this year. The application of our co-accused Ola is of last year. It's filed last year. And we have during all these intervening periods in reminding the court about the presence of these applications and the need to dispose of them. So when we come here on 30th, another pleasant surprise maybe, but now we want to fix them. But you want to fix them, so we are here on the 30th, you say the following day, on the 1st, prosecution should file their response. On the 2nd, we find they rejoin, and today, we hear the application and determine. We are very anxious to get out of prison. We have been there for nearly 20 months. Sadly, my Lord, it is when we have a crisis, deep crisis in our representation, that the opportunity to hear the bail application now springs up. So, my Lord, we actually don't know whether they responded, because we are now totally disabled. If they did, maybe they will have to serve us New Zealand. And how we respond and how the process is managed is another open challenge. So, my Lord, we are faced with a situation, gross violations of the law with impunity. Throughout this process, the illegal kidnap and rendition, the illegal general court martial, the committal without lawyers, and what has transpired in the process of our presence here at the High Court. The latest crisis is caused by a respondent over whom we are complaining. It is the same respondent who deported Martha Karua, senior counsel. And unless we find a solution, the crisis of representation, it's very difficult to see how we shall proceed. We believe that maybe the intention of this terror on our legal team is to make it impossible for us to have lawyers of our choice, so that then the state can be our lawyers, give us lawyers. So, my Lord, our sense is that the rule of law, as we know it, is totally under attack, certainly in the respect of what we are going through. That was the basis of our application 248, which is still to be disposed of. As I pointed out at our last sitting, my Lord, I'm finishing. it's not possible to defend yourself when your hands and feet are tied, when your eyes are covered, and your lips are sealed. As is happening in our situation. This is not a matter that we face just as ourselves, but we believe it's a matter that the whole country needs to deal with. The question of the rule of law is an urgent matter which can face anybody, including you, my Lord. So, my Lord, and we are very anxious to get bail. Afraid to say that in the prevailing circumstances, we have indeed sympathized with our counsel. And let them off. We are extremely determined to insist on our right for representation by lawyers of our choice. And until that is possible, or until court directs otherwise, I think it's only prudent for us to remain in our prison until further notice. Of course, court can choose to go on in any situation, but in that event, we will only be in this court now, not just metaphorically, but physically, on handcuffs and cuffs on our legs. We cannot continue with the process. Where fair trial, fair hearing is not tenable. Thank you, my Lord.